finish your meeting.
Your Honor.
Court calls case People versus Sandra Law. What are we doing?
Thank you, Your Honor. So a part of what we had been discussing with the prosecutor's office required my client to be in some sort of treatment. However, and the court did the order, but not been released to treatment yet, as the court can see.
Is that because they can't find something?
They're waiting on beds. Yes, Your Honor. They're waiting on beds. Your Honor, my client is asking if the court would consider allowing her to do outpatient treatment instead. She could go on a tether. She believes the court may remember this. She's being evicted. It was before the court, and she has until the 12th of December to get her property out of the home, or they're just going to put it on the street.
That was a case before me.
Yes, it was a case before you, Your Honor.
Just let me tell you the name.
Give me a second.
Who was your landlord?
It was Thomas Berry and my daughter Serenity Sturman.
What did you say? Go ahead.
It's Thomas Berry, which is my daughter's ex-boyfriend, and her name is Serenity Sturman, and she just turned 21. And she's going through a lot of problems with this man.
All right, I got you. I just needed to know who the landlord was. Got it?
I do. Dismissed on October 24th.
That case was dismissed.
So she,
When?
October 24th.
October, it couldn't have been, because we have a thing.
Okay.
There's another one, you just
Did we
missed
have
it, and you had to
another?
refile it.
Hold on.
There is no other newly entered case in JS.
Yeah, we don't have another case.
Because they said that you said, because I watched the thing, Your Honor, and you said that he had to refile it because he didn't file it right. He put her name, so he had to refile it under Sandy Sturman and all other occupants. And it's for December.
Okay, but I don't,
okay, but
we don't
the
have a
court has
case.
indicated that as of right now, there's no eviction, is what he's trying to tell you.
It's like we have to move out, or we have to get our stuff taken out by, it's a note, I don't know what you call it. The paper said,
There's a notice to quit.
yes, I mean, that's what it is. We have to help by the
and
12th.
it tells you that you have a certain period in time in which to move out.
Right, okay, that's what.
If you don't, then what happens is they file a court case and it comes before me.
Judge is saying you have more time.
Right, but will I be out of rehab before that?
I
mean,
have no idea when you're gonna finish rehab.
okay, I do have a job. I do have my daughter to take care of. I do have a job. I am enrolled in school through Yale online. Your Honor, I did that to the family. I made a mistake.
No, we're not gonna admit, we're not gonna talk about any of that. Your Honor, my client is just waiting to be released into inpatient treatment. As you can see, she's anxious to get out and to do so.
Can I please be released? I've never missed court dates. I've been on probation with Judge Washington. I've
Your
passed
Honor,
all my jobs.
did I give you a green sheet, Mr. Allen?
Yeah, I have a green sheet. How
So,
much
Your Honor,
time?
we're asking for just a 2-week adjournment. We just need to get her in treatment so that we can work on an offer.
Will be adjourned December 18th, 2025, 9 a.m. Bond continued. Thank
Be
you.
released to outpatient treatment.
She said no.
She did not know that we know there's no case pending. Why are you shaking your head? Go ahead. What? What? You probably should, but I'm not in a hurry for it. Court calls the case before says Grant to see ya.
Ashley calls us for the people.
Stephanie Hanna on behalf of Mr. Grant Decia. Your Honor, he is not present today. It's my understanding the hospital or the place where he's at faxed information to the court, letting the court know that he is
On a misdemeanor, yes.
yes.
We adjourned it to December 17th.
Thank you.
And I don't know where we're going. Oh, it's right here.
I will adjourn this probable cause conference to December 18th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Angel Martell.
Allison, on behalf of the people.
Counter Alexis Plumai appearing with and on behalf of Mr. Martell. Mr. Martell, could you say your full name for the record?
Yes, Angel Edward Martell.
And Your Honor, my client would like to request a preliminary examination.
Your Honor, if I could address bond.
Yes. All discovery is complete.
Yes, Your Honor.
People would have their witnesses available to 16.
We'll do our best, Your Honor.
Set his preliminary examination in person, December 16th, 2025, 9 a.m. Before Judge Moore. As to bond.
Looking at the defendant's jail calls, I have 10 calls to the victim's listed number from his PIN starting on the 24th of November all the way up until the 1st of December. So at this time, I'm going to be asking that his phone privileges be revoked for violating his bond.
Your Honor, no objection.
All right, his bond will continue. Phone privileges are priority revoked.
Thank you, Your Honor.
Thank you.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith.
I think Mr. Smith is on the.
I am
Sir, state your name.
Jordan Smith.
Okay.
And Your Honor, I did send a letter to the court and I attached the prosecutor onto that as well with regard to Mr. Smith being in Hillsdale. I also did talk to the prosecutor about the potential for mental health treatment court. I guess I would ask Mr. Smith as to his expected out date before I ask for an adjournment on this, if there is one.
Maybe. As of right now, there is not a expected
Okay.
out.
Okay.
Okay.
Let's do this then. Let me adjourn this out. I got that communication. I'll grant the adjournment. I'm going to adjourn it to December 30th.
Excellent. Thank you.
All right. Probable cause conference adjourned to December 30th, 2025, 9 a.m. Bond continued.
Thank you very much.
Thank you.
Am I free to go?
Yeah,
Yep, you're all set.
I'll be in touch with you too.
Okay.
Court call
thank you.
case, People versus Matthew Melzo. Thank you, sir.
Water Assistant Prosecuting Attorney for the People.
Assistant Public Defender Don Lieb on behalf of Mr. Melzo, who stands to my right. Mr. Melzo, could you state your name, sir?
Matthew Melville.
Thank you.
I'd like to set this matter for preliminary examination as well as address bond, please.
Discovery is complete.
It is, Your Honor.
People have their witnesses available to 16.
I believe so.
Preliminary examination in person will be set December 16th, 2025, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
As to bond.
With regard to bond, Mr. Melzo has been in custody for the past 14 days as a result of a bond violation for failing to test. He absolutely realized that he should have been far more diligent about ensuring that he remained in compliance with bond, and he is released. He will go to test right away, and he will not have any further violations. He does have stable housing at his mother's home, and I would ask that the previous bond be reinstated or a bond that he could be imposed. He does tell me that he could post up to several $100s. I also want to address what I believe is the low likelihood of conviction in this matter. I did review the discovery, which included the sole evidence in this case being a video of Mr. Melzo sitting in the same chair and leaning down slightly after a previous person had sat in that chair and misplaced their wallet. That
Do
is
you want to do the preliminary examination now?
No, Your Honor. I did want
Okay, go ahead.
I did want the court, however, to be aware of that relative lack of evidence in this case in considering my bond argument.
Okay. I don't need a response. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Court calls the case of the People versus Laura Waldron.
After votes for the people.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Waldron. Ms. Waldron, can you please state your name for the record?
Laura Waldron?
And Your Honor, I have just made contact with Ms. Waldron. She got a new number, so I did get that phone number from her. So I would just be asking.
Your likely story.
No, I did.
Oh,
promise. It's a new
don't
iPhone.
cover for
It's a
him.
new iPhone.
No, don't cover for it. It's all his fault he didn't get it done.
Well, they didn't talk. They didn't call me, and they didn't talk to me when I was in jail either. So,
They didn't?
uh-uh.
Okay, they'll do better.
Okay.
All right. Okay.
Your Honor, I am seeking a brief adjournment on this case, and then I'd like to clarify her bond situation.
All right. What I will adjourn this to December 23rd,
Thank you.
2025, 9 a.m. All right.
Okay.
And as to her bond.
As to her bond, Your Honor, after she got out of jail, she advised me that she either doesn't recall or wasn't informed with regard to any test use provisions. We just want to make testing provisions. We just want to make sure that if she is to test, that that's been ordered so that we can make sure that
How long
she's.
has she been out?
I did do a test with a CPS worker because while I was in jail.
How long have you been out of jail though?
Oh, since the night before Thanksgiving. And then I had court on Monday. I went to court on Monday, but it was actually on Tuesday with Judge Freshour, and that case was dismissed. And so it feels like it's been busy. but yeah.
Give him a second.
No, I'm
Yeah, so
you're just a happy little thing, aren't you?
well, it's like I had a lot going on, and I had a court case, and it got dismissed, and so then I was happy about that.
I like this one, Your Honor.
Yeah, I know,
but
happy.
I am clean, so I can go pee right now.
Hold on.
I am clean, so I can go pee right now. If that's what you want me to do. I'm sorry.
No, it's okay.
Glad you guys are laughing at me.
No, I don't see a community corrections.
As I have from arraignment said the previous bond conditions were reinstated, that may have included a testing order, but if there isn't one, I would ask for one given the nature of the charges.
We figured as much, Your Honor. That's why we just wanted the clarity today.
Good. I didn't mess up.
Okay, so when you're using, what's your drug of choice?
I don't use. This charge is a long charge from a long time ago.
Okay, so when you were using, what was your drug of choice?
It wasn't. They weren't my drugs.
And stick to that.
They weren't my drugs.
Say nothing further.
Okay, these drugs that were not yours, what were you using?
Oh, it was cocaine.
Okay. Thank you. All right, so what I'm going to do in the interim is I'm going to order testing, community corrections testing 2 times per week.
Okay.
Okay?
That's fine.
For bond will continue, we'll add that testing provision.
Okay.
Hold on. Will she need to start that today, Your Honor? I guess.
I can go today. I don't mind.
Well, she's been waiting.
But I do have a question.
Okay.
So I was with somebody at that time, and so.
No, careful.
What?
Talk about the factual.
Oh, okay. Well, I just
Don't
didn't
talk
know
about
about
the case,
if
okay?
they had a lawyer. Am I not allowed to talk to that lawyer either?
No, and that's a question that you can ask me.
Okay,
later,
sorry,
okay?
I didn't know. Okay.
Disregard.
You got your answer?
I guess so. I think so.
Okay.
We can discuss that.
Okay, sorry.
It's okay.
I'm new here.
Here. All right, fine. We'll continue with that condition. We'll see you in about 2.5 weeks. All right.
All right. Okay.
You take care of yourself.
I will.
We'll be in touch. It's welcome. Thank you, Your Honor.
Ms. Phelps, could you state your name, sir?
Ryan Phelps. All right, I have before me 2 plea forms. In the case ending in 5252, plea form indicates that the defendant will be pleading no contest to the charge of retail fraud in the 3rd degree, the 93-day offense. Upon his successful plea to that charge, count 1 would be dismissed, and he would pay the defendant's agreeing to pay restitution as ordered. On the other matter, ending in 1285, the plea form indicates that the defendant would be pleading guilty to added counts 4 and 5, count 4 being assault and battery, that being a misdemeanor, a 93-day misdemeanor, and also malicious destruction of property 200 to 1,000, both no contest pleas, that being a 1-year offense, and that upon his successful plea to that charge, counts 1 through 3, 1, 2, and 3 would be dismissed. And in that case, also the defendant is agreeing to pay restitution as ordered. That's the court's full understanding of the agreement.
Then that is my understanding, Your Honor.
Yes, Your Honor. That was prepared by APA Mabel from my office. That's my understanding of both of those as well.
All right, very good. May I have the defendant sworn?
Right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
State your name, please.
Right. All right. Starting first in the Ann Arbor case, the 5252. So it is this court's understanding that you're going to plead no contest to the charge of retail fraud in the third degree. That's
Yes,
a
Your Honor.
misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. In the other matter, it's also the court's understanding you're going to plead no contest to the charge of assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs.
Yes, Your Honor.
And also, count 5 in that case that you'd be pleading no contest to would be malicious destruction of property, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property which is destroyed or otherwise injured is greater than $2,000. That would become the maximum fine. Do you understand that, sir?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. First of all, it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand that in the City of Ann Arbor case, the 5252 case, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo, the 15th District Court. And in the other matter, you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Lack of memory, Your Honor.
All right. So, sir, to the charge of retail fraud, third degree, how do you plead?
No contest. No contest, Your Honor.
To the charge of assault and battery, how do you plead?
No contest, Your Honor.
To the charge of malicious destruction of property, how do you plead?
No contest, Your Honor.
Now, you understand that by pleading guilty or pleading no contest, you'll not have a trial of any kind.
Correct. Yes.
You signed an advice of rights form, is that correct?
It's Mr. Gaddy. Yes.
Any question regarding those rights?
No, sir.
All right, look at paragraph 5. You'll see a copy on the podium. Those are rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yeah, I understand.
And you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. In the case ending in 5252, the court has been provided and has reviewed an Ann Arbor Police Department report for their case number 2552615. And in the other matter, court has been provided and has reviewed Washington County Sheriff's Office report for their case number 2559315. Any objection to the court having reviewed the reports on either of these matters?
None from the defense.
Based upon a review of the respective police reports, the court does find that in each case there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel? Well, sir, I would advise you that if between the time of my acceptance of your plea and the time of your sentencing, that if you commit misconduct as defined by the Michigan court rules, just do this here, that you would not be entitled to withdraw your plea and you would not be entitled to it. The court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to the...
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will, in the case ending in 5252, the court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court. Sentencing will be January 6th, 2026, 9 a.m. It is scheduled before Judge Valvo, but it will likely be a successor. In that matter, bond will continue.
Your Honor, I did want to address bond.
Of course you did. Or I have not, Desiree. I was just about to do that. Court will accept the defendant to no contest plea to counts 4 and 5 in the other matter ending in 1285. Counts 1 through 3 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in that case will be
January 8th at 10 a.m.
January 8th, 2026, 10 a.m. As to bond.
Thank you. Thank you, Your Honor. So Mr. Phelps was homeless when at his previous failure to appear. He does now have housing he'd be able to stay at an address in Ypsilanti that I can provide to the court. We'd have no objection to a tether of any kind that would allow for his release. He also tells me that he plans to enroll at Washtenaw Community College upon his release. Additionally, since he has been in custody, he's been engaging in treatment services, both with Dawn Farm and Alcoholics Anonymous.
I don't need a response. Motion for bond reduction denied bond.
Thank you, Your Honor.